presenters and for the content to be delivered. So that being said, we will go ahead and begin today's webinar. So again, welcome everyone, and thank you for joining today's webinar, Why Quality Legal Representation Matters for Families Affected by Substance Use Disorders. My name is William Moore, and I am with OJJDP's National Training and Technical Assistance Center. And as your technical host today, I would like to take a couple of minutes to discuss a few features of the Adobe Connect webinar platform to keep in mind. Please note that today's webinar is brought to you by our colleagues at Children and Family Futures. The contact information for CFF is located on this slide. Please note that today's webinar is being recorded. This webinar will be archived on our YouTube page. Please take a moment to view the page where you can see other additional juvenile justice related webinars. For the transcript or any supporting materials, please contact the OJJDP NTTAC Help Desk. For those wishing to download a copy of important documents and resources, including the frequently asked question and the PowerPoints for today's webinar, please do so by accessing the handouts pod, or documents in the handouts pod, excuse me. To access the document, simply click on the name of the file and then click the download button. At the end of today's webinar, there will be a Q&A session where presenters will address some of the questions, including questions that were submitted prior to today's webinar. If for any of your questions for today's presenters, please type them in the chat box as they arise. Now, I know due to recent circumstances that many people probably are not joining in the group. However, if you are or do happen to be joining in the group, please help us count. Go to the chat window and type the number of additional people that may be in the room with you today that are viewing in the group, just so that we can get a good idea of how many folks that have joined us. Again, if you're viewing today's webinar with additional people, please type in the total number of additional people in the room with you today, not including yourself. Please note that individuals at the end of today's webinar will be provided a certificate of attendance, but note that only individuals who are logged in today's webinar will receive the certificate of attendance. If you're viewing with someone and you're not logged in, you will not receive the certificate. However, we do have a group validation form that can be completed that if you'd like to receive the certificate, if you were the additional person viewing it, then you may download that form and send it to us, and we'll be able to provide it to you. You can send the certificate to OJJDP NTTA at usdoj.gov. Again, if you're logged in already, please note that you will get an automated certificate at the end of today's presentation, about an hour after the end of today's presentation. So that being said, I'm going to go ahead and turn it over to our moderator, Tessa. Please, Tessa, take it away. Thank you all.
Thank you, William. Welcome, everyone, and thank you so much for being here today. My name is Tessa Richter, and I am a Senior Program Associate with Children and Family Futures. Children and Family Futures is a national nonprofit based in California. We focus on the intersection of child welfare, substance abuse, mental health, and the court system. Children and Family Futures also operates the National Family Treatment Court Training and Technical Assistance Program, which is funded by the Office of Juvenile Justice and Delinquency Prevention. This presentation is supported by OJJDP. The opinions here expressed here do not necessarily reflect those of OJJDP. We thank them so much for their support. We are so excited to bring this discussion to you all today. This webinar is part of our 2020 Learning Academy series, Conversations That Matter. Along with this live discussion, you'll have access to a short pre-recorded video that your team can watch together and discuss. You will also have access to a take action guide and a team discussion guide to help put ideas into action. You'll be able to access these materials in two ways. They will be sent out to you in a post-webinar email to all registrants within about a week, or you can access them on our Learning Academy webpage. Please see the chat box for that link. Our goal in this Learning Academy package about high-quality legal representation is threefold. First, we want to highlight why high-quality legal parent representation is so important for families, how it can help improve outcomes, and what it looks like. Two, we want to help support attorneys in engaging as full partners in a collaborative team. And three, we want to help the non-attorney partners understand why you want attorneys as key members on your team and how to create those strong partnerships. There are so many exciting policy developments happening nationally to support this work, and we'll be discussing some of those today. Additionally, high-quality legal representation is vital now more than ever during this public health crisis, and we'll be discussing that as well. Today, we have three really impressive panelists representing the national, state, and local perspectives on this topic. Mimi Laver from the American Bar Association, Melissa Thompson, the Executive Director of the Colorado Office of Respondent Parent Council, and Graham Pepper, a local parent attorney from Jefferson County, Colorado, who works on a family treatment court team. Each of these panelists have helped advance the field of quality legal representation, and we are thrilled that they are here with us to have these conversations. We will begin with a discussion with our panelists with the last half hour of our time for open Q&A. Please use the chat box to submit your questions throughout the webinar, now and towards the end. It's also a great way to engage with one another, share ideas, challenges, and resources. Lastly, your questions and comments help us understand what type of PA tools and supports the field needs. So with that, let's dive in. So let's start with our panelists. Mimi, I would like to start with you. Would you please introduce yourself and tell us your why? What makes you passionate about this topic?
Hi, Tessa. Thank you so much for having me, and I'm really, really excited to be here. I currently am the Director of Legal Representation at the American Bar Association Center on Children and the Law, and I've been there for a really long time, 22 years, and I've been working on child welfare representation both for the agency, children, and parents for all that time. Prior to going to the ABA, I represented a child welfare agency in Philadelphia, as well as the Department of Health in Philadelphia. And so I came to this work having some on-the-ground expertise, but not a whole lot. It was interesting in those pre-ASPA days to be representing the department, but everything I've learned since ASPA and since working at the ABA about the importance of making relationships with people with lived experience, representing people with respect, and the impact that high-quality representation can have is exciting and overwhelming. It makes me worried that I was not very fair to some of the families way back in the time that I represented them, and I really cherish the opportunity now to provide training and technical assistance around the country, to work with amazing lawyers like Graham and Melissa, who are just doing really incredible work on behalf of families. So that's why I do what I do, and I really am very excited to be here. Thanks for having me.
Thank you, Mimi. Once we know better, we do better, right? Melissa, could you introduce yourself and do the same? Talk a little bit about why you are passionate about this work.
Thanks, Tessa. My name is Melissa Thompson. I am the Director of the Office of Respondent Parent Council, which we refer to as the ORPC. And our agency is charged in Colorado with providing lawyers to parents who are at risk of losing their parental rights. We contract with over 200 lawyers who serve parents and their families across Colorado. My why starts about 20 years ago when I was 22 and had a lawyer. I had a lawyer because I was fired from a job and I thought they wrongfully terminated me. And I thought my lawyer sucked. And after that, didn't return my phone calls. I was scared. I didn't understand the process I was going through. And after that, I thought, I never want anyone ever to feel like I felt, which was a little lost and scared. And so I decided to go to law school to pursue public interest work, but in particular systems reform, to make sure that no one, no matter what capacity they might need a legal representation, ever felt that they didn't have high quality representation. And so it's something that it's personal to me and I care deeply about it. And I am excited that I have the opportunity to run an agency that is providing high quality legal representation and striving to improve that quality all the time. So I'm super excited to talk to everyone today, and I think this is an amazing group of people to have a conversation about why high quality legal representation matters.
Thank you so much, Melissa. All right, Graham, same question to you.
First off, my name's Graham Pepper, and I'm going to start off with an apology because I have progressive lenses and trifocals, and every portion of this screen is somewhere different in my trifocal. So if you see my head doing this constantly, I'm just trying to see what in the world's on the screen. I started doing this work 25 years ago and have become more compassionate and hopefully compassionate in those 25 years. I want to thank the OJJDP Children and Family Futures and ORPC for allowing me to do this. I became passionate, even more passionate, once I started working in a family treatment court and found out how well it worked. It changed how I practice, how often I communicate with my clients, because I learned the power of consistent communication and not waiting for them to contact me first.
Thank you, Graham. All right, let's get to our second question now. Mimi, I'd like to start with you. Could you talk about what is happening nationally that's exciting policy developments or innovative practices that you're pretty excited about?
Sure. So I think I'm going to take a step back from that a little bit and get to the now with a little bit of history, but I won't go on too much about the history. As I said, I've been working on parent representation and child representation for a really long time now. And as one, we have a couple projects at the ABA that I get to direct. One of them is the National Alliance for Parent Representation, and one of them is currently the Family Justice Initiative. That's a newer effort that fits really nicely with the National Alliance. And through the National Alliance, we have a steering committee of just incredible advocates, lawyers, social workers, some people with lived experience, and I've been working with them since 2006. Melissa's on the steering committee, but we have representation from about 30-some states. And so right there is something that is really exciting, because when we started back in 2006, we only had a few states who could even say anything about high-quality representation for parents, and now we've really spread across the country. And one of our steering committee colleagues who has since retired, her name is Trina Beck, she always used to say, you know, this is a marathon, not a sprint. Don't worry, we're going step by step by step. And that's really has been what's happening. And I think, Tessa, you and I talked a little bit about that marathon and why, for me, that's a good analogy for what has happened. So our first little marathon was writing standards of practice for children's attorneys and parents' attorneys and spreading them around the country and having people alert to the idea that there is something to high quality. It takes a lot of effort, but it does make a lot of difference. And we gave them sort of a blueprint on what those standards were. And then we sort of got people, you know, engaged in that, and so we have the standards going around. And I sort of think of our second marathon as the spread to Oregon, the spread to Colorado, the spread in Arkansas, in so many places. Where we really got more organized, and we have some central offices, and we have people who are living up to the standards and who are trying to engage a multidisciplinary team of representation. And so for me, that's the other really exciting thing that's happening, is the spread of what some people call interdisciplinary, some people call multidisciplinary representation, where we have teams to wrap around parents and have sort of holistic representation, so that the social workers and the peer mentors, whether they're youth alumni or parent partners who have lived experience with the system, can really engage with the legal team and engage with the clients in really authentic ways. And so the spread of that has been happening over the last few years. And then, as many of you know, at the end of 2018, the Children's Bureau changed their policy manual to allow federal dollars to flow down to states for the representation of parents and children. And so in my mind, that sort of started our current and third marathon of how do we really engage with states for them to access this money to use not for roads and not for other kinds of stuff, but to really improve the representation that parents and children receive. And then on April 20th of this year, the Children's Bureau updated that policy manual again and gave a real nod to this interdisciplinary team, because now states can pull down the dollars for the team, for the social workers, for the peer mentors, the paralegals, the investigators, anyone that's working along with the lawyer to wrap around the client. And so that gets us to the current time and perhaps the thing that's really exciting. And so I mentioned the Family Justice Initiative. That initiative is all focused on having every parent and every child have high-quality legal representation when courts are making life-changing decisions about their families. And on the FJI website, you all can access information about 4E. You can see some of the states that have already written MOUs to have the money flow down. And so we hope that that will be a useful resource for you. And I know, and we're going to talk a little bit more about the current crisis that we're in, and there are many families who are really suffering who need high quality representation, and many states that are a little bit nervous about what will happen with the 4E. But please know, like, there are a bunch of us who are here to help support you in your advocacy with your states. And yes, these are really difficult times, but I think from the federal government down to the community level, people are focused on supporting families, and high quality representation is a way to do that. So hopefully that very long answer got to the heart of what you were looking for.
It did. Thank you so much. Melissa, could you talk about how you and Colorado are taking advantage of some of the things that Mimi spoke of, and what high quality legal representation is looking like in your office?
So we actually have drawn down 4E funds, and the money is in a cash fund for our agency's use at this point, which is really, really exciting. But our office has only been in existence since January 1st of 2016. We took over oversight of lawyers on July 1st of 2016, and one of our first things that we wanted to do to increase the level of lawyering in our state was provide lawyers with a multidisciplinary team and really access to resources across the board. One of those resources that I think really impacts quality legal representation is fair compensation. And we went from a flat fee system where in many places lawyers were paid $1,162 for 2 years worth of work for a family, to making sure that every lawyer was paid hourly. And our current rate is $80 an hour. And that is for in-court time and out-of-court time. So paying lawyers to do the important work on behalf of families, I think makes a huge difference with the quality of legal representation available. You also are able to attract really talented lawyers to do this work. The other thing is providing resources. So in a multidisciplinary team, we gave lawyers access to social workers appointed through our office to work on behalf of parents and their families. We gave all our lawyers access to Westlaw for free so that they could do research. We also made a slew of experts available to do parent-child interactionals, different kind of assessments for parents. Our office, if a lawyer feels like something would help a parent, they can come to us and ask for funding for it. And we really increased access to experts and also investigators to work with parents and their lawyers. So I think that fair compensation and access to resources are really a way that we started to improve the quality of legal representation in Colorado. We also are a data-informed agency, and we have a proprietary billing system, and our lawyers bill us for their time by the minute. And they also provide information about what's happening in their cases. So we have the ability to tell, what activities can make a difference, or at least form hypotheses around that. And I think that it's really exciting to talk about data in terms of family treatment courts or families impacted by substance use disorders, because we can tell you and give you information that might help persuade people that using lawyers in this way is really important and makes a difference to outcomes.
Thanks, Melissa. Mimi, I know in the pre-recorded video that we'll be sending out, you speak a little bit about how outcomes improve when families have access to high-quality legal rep. Could you just outline or highlight a few of those outcomes here?
Sure. There have been a few studies, one in Colorado, in fact, and Melissa can talk to that certainly with greater expertise than I can. But in both Washington and in New York City, there have been really excellent research studies to show that when a client, namely a parent in these research studies, have access to high quality representation, time to permanency, all permanency outcomes decreases. In the New York study, the researchers learned that parents and children were reunifying 4 months sooner. The use of kinship was up by, I think, 106%. And the city saved $40 million a year. And so while I would like to think that we provide high quality legal representation because of due process issues and fundamental fairness for families, we also know that money matters. And so being able to tie the cost savings to time in care or reduced time in care does have some impact, especially on legislators. And I think that we will be sharing a link for the study a little bit later in this broadcast.
Thank you. Melissa, do you want to add anything about the Colorado study?
Sure. We, when we started appointing social workers to a legal team, we started collecting data about it, and we published a study that's on our website. But we showed that in some counties, that was basically a pilot program running in 3 different counties, that we doubled the rate of reunification in some places when a parent had a social worker paired with their lawyer as their team, which is really extraordinary. We also saw an increase in placements with families opposed to reliance on foster care, which is really exciting. You can read the study on our website. I don't know if this is a good point to talk about specific family treatment court data, but I will, because it's great. Many people ask questions about, will the cost increase if you start using a family treatment court? And I can speak about the cost to our agency, and the answer is, of course, yes, they increase. But I think it's really interesting what we see in Colorado is that on average, a family involved in a family treatment court, the cost of the entire case is only $135 more on average. More interesting is that the top range of billing you see on cases is vastly different. So family treatment court cases, and this is data coming since 2016, the most expensive case we had was $15,000. But for a regular case, not involved in family treatment court, the most expensive case we had was a little over $43,000. So I think the numbers are interesting. Yes, more expensive on average, but there are other, financial factors to look at. I think it's also interesting when you start to look at outcomes. Like, is there a change? Yes. Families are more likely to reunify in a family treatment court. And our data shows that 61.4% of families reunify who are in a family treatment court versus 49.2% in a regular non-family treatment court case. We're seeing fewer terminations. So less terminations in family treatment courts. A family is more likely to relinquish their rights in a family treatment court, which is exciting. but also we're seeing an impact in the length of stay children are in out-of-home placement. So we're looking for, sorry, I'm pulling up my data on the spreadsheet. For treatment court cases, the average length of stay out of home was 305 days. For a regular case, it was 344. So less time out of home in a treatment court case, which is really exciting for those families, but also there's a fiscal impact in savings to the state when the length of a foster home stay is shorter.
Thank you, Melissa. We were talking before about how it's really exciting to have that data from a statewide view. And so if any of you listening have access to have a statewide office over Parent Council and have access to that, you could definitely talk to them about pulling data about family treatment courts. Melissa, there was a follow-up question. Does Colorado have caps on what attorneys are paid?
Yes, there are caps. And gosh, off the top of my head, I think it's Graham actually might know better, $3,000 for a trial court case and $4,000 for an appellate court case. However, lawyers can request to exceed those caps, which makes sense. Sometimes these cases take a long time. Families' issues are complicated, and there hasn't been a time when I told a lawyer that they needed to stop doing the work because I wasn't going to pay them anymore. I think they need to tell me why they need to keep working on the case or what's making this a particularly expensive case. So yes, there are caps. Yes, they are exceeded.
Thank you. Graham, going to you with what Mimi and Melissa spoke about with some of the national and state changes, how have you seen that affecting your practice and ability to work with families?
Well, I think from the beginning, with the whole purpose of starting our family treatment court was, the sole purpose was to decrease the amount of terminations that were taking place. Our juvenile judge at that time was tired of terminating parental rights. He saw how devastating it was from every perspective, how devastating it was on the parents, how devastating it could be for the children. And I think cases, and I haven't asked him specifically, but cases that came back with failed adoptions leave a mark on every single person that happens to. So how it changed how I practice, and specifically all the practice in Jefferson County over the last 10 plus years, we have initially started with family treatment court, initially started with that goal of reducing the number of terminations. What we found out is that in the first 5 years, we were great at that. But we weren't necessarily great at other things, which was getting kids out of foster care quicker, having kids with families quicker. So because we study these numbers all the time and we allow what we learn to direct what we do, we were able to get better at that. And our family treatment court has substantially fewer days in out-of-home placement, has substantially fewer clients whose children wind up out of the home, have substantially fewer clients whose children are placed in foster care versus relative care. And as we learned how to do that, we obviously asked ourselves, well, why in the world wouldn't we be doing these same things we're doing in family treatment court across the board? And at those numbers in Jefferson County of how far ahead we were in keeping kids in the home, keeping kids with relatives, keeping kids in foster care for fewer days, has dramatically decreased. Now, I have the good fortune of being both a guardian ad litem and a respondent parent counsel. And I think that's helped me be a better lawyer. Because I'll tell you, every time I represent a parent, every single time I represent a parent, they really want three things. They want their child home, they want social services out of their life, and they don't want to see social services again. And everybody thinks being a guardian ad litem is somehow magically, drastically different than being a respondent parent counsel. But guess what kids want? Kids want to go home. That's mom and dad to them. They want to go home. Kids don't want social services in their lives. It's embarrassing. It's taxing. It's agonizing. And guess what? They don't want them to come back again. So each and everything that we have done was to make sure that what we're learning in this family treatment court isn't just staying here. For example, the two biggest things that we did to improve the quality of representation and just the overall quality. Our family treatment court used to put people in jail for not doing what they were supposed to do. And guess what our numbers said? Everybody that went to jail didn't complete the program. So we stopped doing that because it wasn't garnering a positive result at all. As a matter of fact, it was an extremely negative result. The other thing we did to make sure one of the things that was successful in how we're helping parents is right up front, getting them into treatment. So instead of just concentrating on that, if you choose to be a part of the family treatment court, or if you choose and there's enough room to be in the family treatment court, things that are realities that go on, we have a substance abuse expert at every temporary protective custody, which is the very first hearing. And if this case involves substance abuse, and it doesn't matter whether it's going to a family treatment court or not, they have access to that expert. They can get their appointment set that day if that is what they're looking for to get an evaluation. And getting our clients to an evaluation and to treatment, the quicker we do that, everything else happens quicker. And we don't lose our clients like we do when we take 6 weeks, 12 weeks to get them to the treatment that they desperately need.
Thank you, Graham. We had a question about the family treatment court model, and so I do apologize that we skipped right into that. I recognize we have a pretty broad audience. I'm actually wondering, William, would you please pop up the poll question we'd like to know how many of you are part of a family treatment court team. Yes, not at all, or no, but you're familiar with the model. This will help us a little bit. About 1/3, 1/3, 1/3. Okay. All right, well, I will take just a moment to explain the model then for about the third of us that aren't too familiar with it. The family treatment court model is a collaborative model between child welfare, the court system, substance use disorder treatment, attorneys, and children and family services. And it was created to help families who are involved in the child welfare system when the parents have substance abuse issues, to help serve the family unit, to repair those relationships, to help the parents complete treatment and move into recovery. And all treatment courts typically have some goal around permanency, reunification, those sort of things. So it is similar, built off of the same model as adult treatment courts, veterans courts, mental health courts, but it is within the child welfare system. And so that is a good segue into our next topic, thinking about what is the role of an attorney on a collaborative team? So even if you're not part of a family treatment court team, how can an attorney engage collaboratively? A lot of times we hear questions or concerns that you cannot be a zealous advocate and collaborate. So can we go ahead and start with that question? Mimi, would you speak to, is it possible to collaborate and zealously advocate for clients at the same time?
I bet nobody's going to be surprised. I think all of us will say yes. It is absolutely possible to do both. And I will defer to Graham for the nuts and bolts on how he does it. But from a system change level, I think it's really important that lawyers who are engaged in family treatment courts and other collaborative efforts are part of all of the system change efforts and reforms that are happening in states. Because I think those lawyers get to see the best practices on the ground and they can elevate those practices. And I have worked with a few states where I talk to them about the idea of coaching parents attorneys, because sometimes parents attorneys come to this work, many of them with criminal defense backgrounds, or just they're litigators. They love to be in court. They love to argue. They love to zealously represent. And they sometimes forget that zealously representing and zealously advocating for clients really means working hard to get to what the client's goal is. And it doesn't always mean yelling and screaming and having theatrics, although as a lawyer that is always fun. It means really working within the system, right? It means being a good partner at the table on a case level, and it also means coming to some of the system change work ready to maybe listen and just for a minute and hear what's going on and then bring the voice of your clients to that table. I also, of course, recommend that parents and children's attorneys remind the other system players that it would be great to bring representatives of their clients to those systems change tables. That it's not just the attorneys that need to be there, but the parents and the children themselves, so that they can talk about what it really means to experience the system. And I think when lawyers can come and put on their system change hat and be good collaborators, that goes a long way in building trust, so that in the cases where the lawyers do need to sort of elevate their theatrics, everyone understands that they're doing it because this client needs that level of zealous advocacy. And I think there are a lot of definitions and there's a lot of gradations within zealous advocacy, and I'm real curious to hear what Melissa and Graham have to say.
Me. This is one of my favorite topics, because it is the question that comes up all the time about when lawyers are involved in child welfare. And I think that what is sometimes a misconception, and it can come from lawyers or it can come from people looking at what lawyers are doing, but collaboration is zealous advocacy. You have to be a good collaborator in these cases. And that doesn't mean that you just do what the other side says they want you to do, or that one person's opinion about a case is right. But it's making sure that you've formed excellent relationships with everyone in that team, and that you use your voice wisely to convey the needs of your client and what might be the best fit for them as far as treatment. Lawyers are key to parent engagement. Because they are the person that is going to, I think, closely establish trust with the client. And it's also working to hold the team accountable to what the law says, what due process means. And I think sometimes in a regular DNN case, not certainly not every case, sometimes we're waiting for a parent to fail. Especially when they have a substance use disorder. 52% of our cases have a factual basis that involves substance use. And so many of those clients struggle to succeed in a regular case. And I think that what's great about family treatment court is, instead of, asking the parent, well, what have you done to get access to your treatment and do the 9 things that are on your treatment plan and get your bus pass and maybe get everywhere you need to get all your appointments set up when you don't have a phone. I feel like family treatment court, and the lawyer in particular, is asking the team, like, what can we do to support this parent in being successful? Because they came to this program because they said, I want to be successful. And I think that it's the team and family treatment court asking that question, and it's sometimes the parent's lawyer saying, hey, we need to go back to that question and go back to, objective information about this parent and what we know works. Obviously Graham said putting people in jail doesn't work based on the data. So I think lawyers are key collaborators, key relationship builders, and those are some of the things lawyers can bring to these cases to help engage parents and help make sure they succeed.
Thanks, Melissa. And Kimberly, we saw a question from you about handling families that don't comply with treatments. And I think, Melissa, some of your statements there about having a parent be the advocate for the, I'm sorry, having the attorney be the advocate for the parent and have their voice, are those things that you all are seeing help increase compliance and engagement?
Graham, do you want to answer that from your perspective?
It's a huge part. I know there are some statistics in family treatment courts that show that, but here's just the practical point. One of the things that Office of Child Respondent Parent Counsel has done is hire investigators. And I will tell you that the losing contact with your client is infuriating, difficult. You know the client wants help. You know the client wants to be back with their children. And one of the great things that has happened, other than somebody in my office understanding Facebook and how to reach out to somebody on Facebook, is that the Office of Respondent Parent Counsel has investigators to help you find your client. This is a huge role, contact with the client, building a relationship with the client, making sure your client knows you're on their side, and it's you and them. You're not a part of they. You're not a part of them. You're on your client's side. And when we lose track of our clients, which happens frequently, they lose phone numbers. I was stunned. I thought I was a genius, and I'm reminded daily I'm not. But I thought I was a genius when we started to make sure we got emails, because we were going to communicate with our clients with emails, and we would get rid of this problem of losing contact with our client. Well, guess what? Clients don't have phones that get emails all the time, just like they don't have phones to call you. Clients don't have access to computers, especially in COVID-19 when every library in the city is closed. And clients forget their passwords, and clients, you lose track of them just as much. So one of the resources that has been hugely helpful is these investigators, because these investigators can find family members, find phone numbers for family members, make contact with your client, and we find out the client, and the reason they haven't had contact with us isn't because, boy, I don't care about my kids anymore, or I'd rather my sister raise my kids. That's not why we lost clients. We lost clients because they were in the throes of their mental health issues, their addiction issues, their homelessness issues. And when we reach out and find them, we're finding a good percentage of them start communicating with us. But that is us having to make the effort first. That isn't the client coming to us and us saying, oh, okay, I'll return a call or I'll return an email. That's us proactively trying to find the clients. And without the Office of Respondent Parent Counsel, I don't know if we could get there. I do see a question about attorneys against family treatment courts, and I can address that, Tessa, at the appropriate time.
Can I weigh in a little bit?
Go ahead.
About what Graham said? So investigators are huge, and I think that the undercurrent of what's going on with parents sometimes is that these cases are full of shame, and then lay on top of that someone who has a substance use disorder or a mental illness, and they think sometimes that nobody cares about them, and nobody wants them in court because in some ways, like when you end up in court in a child welfare case, like it feels like you failed as a parent in so many ways. And one thing that was really like a beautiful story about an investigator, a lawyer asked for an investigator to find a parent, and that investigator tracked down that parent, and the parent started referring to the investigator as my investigator came and found me. And that parent started coming to court and engaging in treatment. And it was because, that investigator reached out, and that lawyer used that investigator to reach out at the right moment in time when a parent was ready to engage. And I feel like so often, so much happens at the beginning of a case that's so challenging and confusing and hard. And parents sometimes just fall off the map because it's more than they can cope with. And I think that it's important to reach out proactively often because there's, parents don't want to parent, even if they're not showing up in that case at that moment. The things that they're dealing with are hard.
Thank you, Melissa. I think that's super important, and it ties in a lot to what we talked about when we were all sharing together, looking at what the role of attorney is and what ethics requirements and training looks like. So you all are talking about substance abuse and mental health and some really tricky things that I'm guessing your law school education didn't cover too much of. Could we talk a little bit about, could you address the non-attorneys in the group, the non-attorneys who are on treatment court teams who might struggle a little bit about what's going on with attorneys, why they're maybe acting certain ways, doing certain things? If you could share what the biggest misconception is about your role, what would you share? Melissa, let's start with you. See, I'm thinking as an attorney, not necessarily in your role as a leader.
So there's no training for this in law school. And I remember, one of my very first clients who was crying and in crisis, and I was like, I don't know, no one told me, I wasn't trained as a therapist. I don't know how to deal with someone in crisis. I know how to read the law and file a motion and show up in court and litigate something. But I think that the challenge, of becoming a lawyer who's working in the public interest and working with at-risk populations, impoverished populations, is learning that you are not just a lawyer, you're a counselor at law. And the conversations that you're having with people aren't just about, well, this is the right that you have. It's about these are the things that can happen in court that are going to impact your life, and what do you want for your life? And there isn't a what do you want for your life class at law school. I think many lawyers learn this and are drawn to the work because they're good people, and they're compassionate people, and they're good with empathy, and they're drawn to the work because those are their strengths. And then the work challenges them to be better and learn how to help people in that arena. And the same ways that, social workers learn to help people in that arena, but I think they get more training. I think that the other part of your question was what's misunderstood. I think the thing that's misunderstood is confidentiality, that lawyers have an ethical duty to keep their clients' confidence. And that's true in a regular track case or a family treatment court case, and it's necessary because in order to gain someone's trust, they have to know that you're going to keep their secrets. The flip side of that is that I think lawyers know, and at the heart parents know too, if you aren't honest about the things that you're facing in your life, you're not ever going to get the appropriate help to have, the things that Graham said, families want, which is social services out of their life, their children back, and never to see social services again. So lawyers are good at having conversations about, hey, here's this problem we have. You had a hot test. How are we going to respond? What's the best response for you? How am I going to talk to this about with the team? What are the things you want me to raise? How can I be the best advocate for you? But also, how can we deal with this so you can get social services out of your life, you can get your children back, and you don't have to see them again?
Wonderful. Thank you. So we have about 10 minutes left before we're going to go to open Q&A. Let's shift a little bit to the current public health crisis. Mimi, could you talk about what an attorney's role may be during these times and what you're seeing across the country?
Sure, Tessa. I think now more than ever, families really, really need engaged client contact. Lawyers who are out there working with their clients, reaching out, like Graham just described, being really proactive to see how are the clients handling the situation. Many of our clients are people who are already living in poverty, and this current economic crisis is hitting them particularly hard. both from a health point of view and an economic point of view. And so clients need what I've been thinking about as creative lawyering. They need lawyers who are going above and beyond in ways, again, that, like Melissa said, that we weren't trained in law school to do. Some lawyers are, and their teams, their peer mentors, are delivering food. They're delivering can openers to open cans in shelters where families can't use the joint, all of the appliances. True story. They are advocating outside of the courtroom so that their clients who are living in rural areas where there are no cases, who have children who are old enough to understand 6 feet, can have face-to-face visits, right? They are just trying to think about all of the creative legal arguments and non-legal arguments that child welfare agencies and courts can stay attuned to. They're also working hard to figure out what to do when courts are closed down. And I think now we're coming out of that and courts are opening, but not all courts are opening for every case. And some judges aren't seeing visitation as an emergency, whereas parents and children are seeing visitation as a huge emergency. And so really being strong advocates to explain why it is that parents and children in this difficult time really need to lay eyes on each other, and if possible, in person. If we can help, do it in a way that's healthy, let's have in-person visits. Attorneys are also working collaboratively among themselves, agency attorneys, parents attorneys, children's attorneys, and caseworkers, to figure out which were the families who were close to reunification before the crisis. And but for the crisis would have started with their overnight visits, would have gotten weekend visits, and they're putting those cases forward as cases that should just reunify now. If there's no reason not to reunify, then absolutely it is so important that children go home. And so looking at safety issues, and if there are no safety issues, get those kids home. And so that's been exciting to see. And I think one other area is this whole question of virtual visitation. Attorneys for parents and children are helping to think through how do we use virtual visitation creatively, and how do we hold on to that later when we get to have in-person visits for all families. How do we also hold on to the creative use of technology for reading bedtime stories or watching movies together or going outside and describing what we see. It will never be better than in person, but it can be in addition to in person. So I think the lawyers who are thinking outside the box and creatively are getting better outcomes, of course, for their clients, and it's really important that all of us on this call who are lawyers and non-lawyers try to think big about how we can support families, because they need a lot of support right now.
Thanks, Mimi. Graham, do you have any examples to give on the front lines, what you're seeing in Jeffco or in Colorado?
I've got a few examples, and the key is about collaboration. We don't have access to our courts like we did. We can file a motion right now and get a hearing set in July or August around parenting time and around returning a child home. That's if a court deems it necessary. So as an attorney, if you don't have the ability to work with the caseworkers, to work with the county attorneys, and to work with the guardian ad litem outside of the courtroom, you're really doing a disservice to your client. So COVID-19's really brought out those collaborative skills. And I got to be really clear about the definition of collaboration. I think a lot of people define collaboration as we all got along, we all agreed. That's not my definition of collaboration, and I don't believe it's a true collaboration if that's what it is. What I think is a collaboration is people with different views come together, express those different views, and build a better outcome than if we all came and agreed. So in other words, it's important to have the attorney for the parent there to make sure they're pushing what that parent wants, making sure that they can do what should be done. And the biggest example for me was these virtual visits. There's three things that occurred with these virtual visits. Number one, was panic. And the panic was, they're going to be lousy. All my clients are going to be doing this. And we're never going to get a kid reunified. So step number one is we looked at how many of our cases really were going to be virtual visits. Well, we found out in our office, only about 20% of our cases were going to be virtual visits because the other cases had either the kids at home, but most importantly, kids with relatives. And guess what? Kids with relatives that didn't have supervision by a professional didn't require virtual visits. They didn't violate any stay-at-home order by seeing their child with a family member. So it's like, well, that's kind of nuts. If Billy can see mom because Billy's with mom's sister, why in the world are you prevented from seeing your child face to face just because it has to be professionally supervised? One of the solutions that we found to that issue was finding a family member who was willing to allow both the child and the parent in the home, foster parents that were comfortable with allowing the child to go in such a small setting, and 3, we social distanced by having the supervisor be present virtually. So they weren't coming from one child's home to another child's home to another child's home. They were participating virtually and were still supervising the visits professionally. And, you had to make sure they stayed in the camera. Now, we've had a few situations, and this is kind of the most extreme, where none of those solutions worked. And we really were in a virtual situation, and Mimi, it was exactly what you're talking about. We were on the cusp of returning home. The biggest one we had in our office was where a client was living in a sober living environment, so there were many people in the sober living environment. The sober living environment wasn't allowing the people come in. The foster mom couldn't go out and meet in a park because the foster mom had an immune deficiency herself, so she was limiting the amount of outside contact. And we had to do exactly what Mimi said. We had to determine what the safety was, and we had to work with all the parties, the parents' council, the guardian ad litem, the caseworker, about how can we return that child home. And instead of just stopping and halting everything we would do in a normal way, we were able to return that child home, and I believe safely. It's been a week, so I'm not going to brag after a week, but you gotta challenge everyone's thinking. And that is certainly a situation where I frankly was the guardian ad litem, so I was challenging myself, and others were challenging me to make sure I wasn't just sitting out there and saying I need 30 days of clean UAs when I don't know the next time somebody's going to drop a UA. So the power of collaboration is really key. The power of the attorney for the parents being involved is how you make sure those parents get the help they need.
I think I agree completely with Graham and everything that Mimi said about what lawyers are doing right now, but I really think lawyers are first responders for families. The same way that caseworkers are first responders for family, we're dealing with a level of crisis that I think is unprecedented, and it's terrifying. But what's something that's really interesting and supports exactly what Graham's saying is when we were looking at our data about what lawyers started doing, when they couldn't travel to court anymore, they're having virtual hearings, they're still billing us for court time because it's just occurring virtually, but we thought our billing would go way down. It did not. It actually went up, and in particular, it went up in client communication and communication with others, which shows that lawyers are picking up the phone and calling and trying to solve problems and trying to offer creative solutions to the crisis families are experiencing. And I think one place that was really, great to work with was Mesa County, because I reach out to the counties across the state and say, we want to partner, we want to help. And in Mesa, the department provided iPads, and my lawyers delivered them to parents so that parents could have that communication tool. So if virtual visits were what they were looking at least they had something that would work for them. I think that lawyers can be such great creative partners in times of crisis, because one thing we are trained through our experience is dealing with crisis all the time, and coming up with creative solutions for people.
Thanks, Melissa. Well, we are getting ready to move into the open Q&A. I do want to say we're seeing a lot of great questions coming in that are looking for resources. And so what we're planning to do, we're going to talk about plenty of questions in the next 30 minutes, but also we will likely do a written Q&A and get some resources out for some of the things you all are asking for. So please watch for that along on our website. Also, as you're listening to this, for the about 30% or so who aren't too familiar with the STC model, or for the 30% of you who are but are not part of a team, or for the 30% of you who are part of a team but want more resources, feel free to email us. We'll be putting the email address in the chat box here for more information about collaborative models, about family treatment courts, anything along those lines, and we'd be happy to support you in that TA. So let's go ahead. There was a question early on about family treatment courts. Let me see if I can find it here.
Hey, Tessa, can I answer one of the questions that just came up while you're looking for the other one? Because there's a question about reunification, and it builds right on what Graham was saying, and I would really like us to just talk about that for a few minutes because it's such an important piece of family treatment court and all court. So I want to acknowledge that people are thinking about how do we be creative about reunification and how do we try to convince our team members who aren't on board. I want to put in a little plug that June is National Reunification Month. We're coming up on it in, 10 days. One of my favorite times of the year when people all across the country start to remember that reunification is our primary goal in child welfare cases. It's our primary legal goal, and it is what families want most. As Graham said, that's what parents want, and that's what children want. And we know from all of our study in the last many years about trauma that separation is traumatic for children and for parents, and the longer the separation goes, the trauma increases. And so I think when you're talking to your team members, really frame for them that outcomes for children who are at home are actually better, lifelong outcomes, than the children who have been removed. That so many cases, the children are removed because of what is called neglect, which often means poverty, and that we can, as a community, wrap ourselves around the families once they're reunified. Once a child goes home, it doesn't mean that the system has to be done with that family. We can find supports as a team to make sure that there is a safety net, to make sure that the parents know where to go for those supports. And I think as your team members become more comfortable with the idea that a family is connected in the community, they may feel a little more comfortable with that idea of a child going home. There are so many factors in each situation, but just because a family is substance use involved does not mean that they can't parent. And it's so important, and I don't think we've really made that connection yet in this call, that there are many people who are not living in poverty who use substances and their children are not removed. All too often, children who are living in poverty are sort of targets of this idea that, oh, there's a dirty drug screen and therefore child must be in danger, where it may not be true. You really need a connection between the substance use and the parenting to feel comfortable with the removal or to justify a removal. And you need to know that a family has focused on protective factors, has a safety plan, a safety net in place, and then I think, really advocating with your team members about that reunification. So just wanted to do a little plug for the importance of all of us in advocating for families staying together. And Graham and Melissa, I'm sure you have other thoughts on that as well.
I do think that ties into a question that we received about parents with substance use disorders. Can you speak to parent representation specific to parents with substance use disorders? What's different and what is the attorney's specific role? Melissa or Graham, do you want to start with that?
I think the most critical thing is having some understanding of addiction. First off, you've got to be comfortable and learn the fact that this is a disease. This isn't a shortcoming. This isn't about willpower. This isn't about if you want it hard enough. This is a disease, and the disease needs treatment. So you need to be able to advocate to getting to treatment quickly and advocate from the first time you get in court for an assessment or evaluation to be done for treatment. Advocating throughout the case that if your client is really struggling, and I can't tell you the number of clients who said, I really need inpatient therapy, and for any number of reasons. Budgetary is the worst reason. Others are valid reasons. We need to have an evaluation before we can send somebody to inpatient treatment. We don't have beds. That's not a valid reason, but it's a reality. You've got to be able to advocate for that and understand a little bit about that process. So in other words, if what's holding you up is this client is struggling so bad with their addiction, they haven't been to treatment and they haven't been assessed, you got to get them another assessment so that the treatment provider can make that recommendation. Without it, Medicaid's not going to be reimbursed. So you just have to have some knowledge of that. And you have to be able to, with all clients, and it doesn't matter whether it's substance abuse or not, you have to be willing to reach out to them. Substance abuse disorders, calling your attorney is low on the priority between staying warm, trying to make your appointment with her to see your child, finding a place to sleep that night. Those are all high priorities, and calling your attorney is a lower priority.
You know, I wish there was a prescription that, you know, we could say, like, if a lawyer does X, Y, and Z, a parent is going to have more success. And there isn't a prescription. You know, one thing that we tell our lawyers, like, if you see a cookie cutter treatment plan that's just the same thing for every single client, challenge it. Because I think it's incumbent on all of us to look at a person who's coming to court with a substance use disorder and ask, you know, well, why? You know, is there ongoing trauma? Is there mental illness? And understanding that person and coming up with a solution that's just for them. Because I think as an advocate, we're not doing that person justice if we're just saying, well, you do X, Y, and Z, and then that's what we do for someone who has, you know, a meth addiction. I think another thing that lawyers should do across the board, but as you're a lawyer involved in a treatment court, I think you understand treatment better. You understand resources better, how people can access them. And I think an interesting thing that, you know, we sometimes see is not all our lawyers are saying, here are the things in the treatment plan that you should you need to accomplish. Here are these other things that I know from my clients' work. Like, here's a support group. One thing that the ORPC has just started implementing is a partner, a parent advocate, someone with lived experience. And we actually have that person working in Jeffco doing an amazing job. He suffered from addiction for decades. And he's going in and talking to clients in a language they understand about, you know, his experience. But I think the thing that he brings is a sense of hope. And I think someone asked a question about, you know, needing to have a parent on this panel. You're right. I think hearing from people with lived experience talking about, you know, I started here and look where I am, and you can do that too, is one of the most powerful things that systems can provide.
Thanks, Melissa. So we received a specific question to family treatment courts, and it's in line with a lot of TA questions we get about parent attorneys. What advice would you give if you have attorneys who advise their clients against family treatment court participation? Along with that, we get a lot of questions about, can attorneys support their clients in entering a family treatment court prior to disposition? So along those two lines, can any of you speak to that? Graham, do you want to go?
I can. I wasn't an attorney who didn't recommend family treatment court, but I got to tell you, I certainly empathize and feel like I have an understanding. The first time I saw family treatment court, I just about fell over. I only saw the trees. I did not see the forest. And fortunately, it was a large group of people witnessing this, and everybody but me saw the trees, or the forest. And what I saw was a parent standing at a podium next to an attorney selling herself down the river, literally. She was not Chris Farley, but she visited her boyfriend in a van down by the river, and that's factually true. I'm not making that up to be funny, and used meth, and is telling the judge all about this. While in my head, I am screaming. I'm like that goat in that video, just shrill shrieking inside my head. I'm saying, stop the bludgeoning, stop the bath here. Somebody shoved the microphone over. Somebody pushed the podium over. Anything to stop this poor woman from selling herself out. And why is her attorney sitting there watching all this go on and not saying a word? Well, fortunately, the next day I spoke to our juvenile judge, who talked about how powerful that was and what he saw from the compassion from the bench and the relationship that that judge had with that client. I went, okay, maybe there's something here. Maybe I shouldn't be opposed to this. And I'll tell you, once I got involved in a family treatment court, I became a quick believer in it. One reason is I had a very low functioning client and had a significant, very serious meth addiction. And what's worse is she didn't look either of those. Her hair was always perfectly combed. She always was appropriately dressed. She always looked like she was paying attention. And if it weren't for the fact of the professionals that didn't have law degrees, and quite frankly, a licensed clinical social worker who realized how low she was really functioning. And you know what? We found out she wasn't making any appointments. She didn't know how to ride a bus and make a basic bus schedule work. And that was life-changing. But the biggest thing is, if you have an attorney or group of attorneys that are opposed to family treatment court, I think teaching them and training them is the most important thing. And if you teach them and train them on these three things, they will understand that zealous advocacy means we probably need to help get clients to treatment courts. Number one, find out what your client wants. When they do that, they're going to find out their client wants their children home. And number two is, as a zealous advocate, you've got to figure out how to get what your client wants. Well, you'll find out that in family treatment court, you're going to get your kids home quicker. You're going to be able to keep them home. You're more likely, significantly more likely, to have the case end with the children at home. And you're significantly more likely to have social services either not come back in the case in this family's life again, or if they do, they need a tune-up. And what we found when we started studying the cost of this program is that families that didn't go through family treatment court and wound up back in human services were high expense cases that were going to either custody to relatives or terminating, and their kids were being adopted. For those who came through family court and had to come back again, they just needed a little tune-up, and they were low expense cases. So for attorneys, it's a matter of just teaching them what the benefit is of your family treatment court. And I'm lucky. We've got a family treatment court with a numbers guy that, I mean, he graduated from one of the many schools in this country I could never get into. But he keeps track of everything we do, and we can support these claims. So these claims that I make are all supported by data that we've combed over the last 12 years.
One thing I want to add to what Graham said is I think sometimes why attorneys are reluctant is because they're concerned that judges are involved in these pre-court staffings. They're hearing everything about a family. They're hearing hearsay. And I think what is important to remember is that happens in a regular case. A court gets a court report. Sometimes they contain hearsay and lots of different things about a family that a lawyer was like, well, that's not accurate, or I would have said that differently. The benefit of a family treatment court is you're in the room as the judge is hearing that information, and you can advocate for that parent and help them understand, oh, there was a hot UA, this was it, or oh, there was a hot UA, you know, I think that it might not be hot, can we have a confirmation test? You know, I think that the benefit of being at the table in the room when those conversations are happening is huge, and I would encourage lawyers to shift their focus and how they can be an advocate in that arena.
Tessa, if I could just add one or two other things. Graham mentioned data, and I think it's really important if you're working with a group of lawyers who are resistant to show them the data. And if the data isn't quite as great as what Graham is talking about from the JEFCO family treatment court, get the lawyers involved in helping to get the outcomes better, right? The lawyers need to be at the table, need to be engaged. But talking to the lawyers about what you're seeing with the data makes it much more concrete. Most of us lawyers are very concrete thinkers, and we want to see what's happening. It's also important, I think, for lawyers to understand that your treatment court has a reunification mission, that even in some treatment courts, it takes a little longer for kids to get home. But as Graham said, the kids then stay home. They go home safely. They don't return. And there is not a push necessarily to get off of the reunification train. And so if your treatment court really lives up to both that vision and the mission by actions, in terms of reunification, then you can, with good faith, recommend that your client enter that treatment court. So really understanding how this treatment court operates if it's new to you and what their goals are for the long term of clients.
Thank you so much, everyone. Well, we are going to wrap up the open Q&A piece here. Just a few reminders that if we did not get to your question, there were so many good questions coming through, so we apologize we couldn't get to them all. But if you would like a specific response, please drop your question and email into the chat box, or you can email us directly at sdc@cffutures.org, and we'll have that in the box as well. We're going to close with one question each, or one question for each of our panelists. In one or two sentences, in about 5 years, what do you hope for families affected by substance use disorders in the child welfare system? Melissa, let's start with you.
So I think that we know that there are always going to be families who are impacted by substance use disorders. That's not going to change. People are going to have that experience, are going to come to systems for help. The systems need to change their response. And I think that my hope for the future is that everyone has the right framework for the response, and that they understand addiction is disease, and they're looking for resources that really work. I think in 5 years is my pipe dream, that families who come into this system can remain with their children in treatment and stay together. And right now I think it's a rarity that, you know, a mother can go into a treatment with her baby. I think that needs to be the norm, so that families can really be together, because that's our ideal, keeping families together, and get treatment for what is a disease and shouldn't be a shameful experience. And I think that is my hope for the future. I also hope that if you're someone who's considering this kind of court, that you do it and be bold. Because 3 years ago, there wasn't an Office of Respondent Parents Council. And I think that bold change can yield great things for families.
Thank you, Melissa. Graham, your thoughts?
My thoughts were, Melissa, really, that is my thought. But just to build upon that, I would say I want to make sure that I personally am challenging myself to not see the word heroin, opioids, or meth and say the child can't be there. And I would hope every professional challenge themselves when they hear any one of those 3 words. Not, hey, the child needs to be removed, but hey, how can we make it safe for the child to be in that home? And that gets us to the next part that is really difficult. The real way to do that is through treatment and appropriate treatment, whether it's inpatient and the children can be at inpatient, or whether the parents can do intensive outpatient but need supports in the home. And those are where we are going to be lacking. And quite frankly, with COVID-19 and what that's going to do to state and federal budgets, it's going to be harder to advocate for that. And we're going to have to find better ways to find a way for that to happen.
Thanks, Graham. Mimi?
Sure, thanks. My hope for the future is that all families who are involved with the child welfare system can say that they feel like they've been treated with respect and dignity, that if they are involved, if they are substance involved, that they, as Melissa said, get to be placed with their children. That really we need to be organizing that in a way better way, because it makes a world of difference, and we now have research to show it makes a world of difference when babies room in and when young children are placed and all children are placed with their parents. And I really hope that the interdisciplinary model of legal representation grows so that all parents have access to peer partners and people with lived experience who really can understand where they are and how they're progressing in their case, and the clients can be wrapped around with the help of people who have already successfully managed the system.
Thank you so much. Mimi, Graham, and Melissa, I hope you take a moment to look in the chat box. You're getting lots of accolades for your work. And I saw a comment that someone has a lot more appreciation for the attorneys that they work with. And so I think that's huge. We want to see that, that attorneys are really important pieces of the team for parents, for children, and for families. So before I turn it back over to William, I just want to close up with a few reminders. We will be sending out the email with the pre-recorded video presentation, which Mimi hosted for us and shared a lot of really great information about high-quality parent legal representation, what that looks like, and why it's important. We will also have the team discussion guide and the take action guide. If you are interested in getting notifications about these Learning Academy webinars, feel free to drop your email into the chat box and we can add you to our listserv to get those notifications. Our next topic will be around working with families affected by substance use and domestic violence, which we have been getting a lot of requests about, a lot of needs in that field. That will be in late summer. Thank you all for joining us. We really appreciate your time and your desire and commitment to serve children and families affected by substance use. Thank you so much to our panelists, Graham, Melissa, and Mimi, for being here today and for your work in the field. And with that, I will turn it back to William.
All right, great. Thank you very much. And before we adjourn, I do want to thank the audience for coming in and actually joining today's webinar and being very, very active. Before we do end, really quickly, I'd like to go over a quick poll question that I was supposed to do in the very beginning. My apologies. I know you all's knowledge may be different now because you probably learned quite a bit, but I guess if you can think about before you attended the webinar, how you would rate your knowledge versus what it is now. So feel free to complete that as if you were before, and I'll just leave this up for a couple of seconds really quickly just to gauge the audience. And again, thank you all remaining for just completing this particular poll question. So that being said, I'll go ahead and end the poll here, and thank you all for completing that. And before we end, just a couple of quick reminders for everyone. So please note that if you are interested in getting in contact with OJJDP's NTTAC, you may do so with the website displayed on this current slide. You can select the link there. It is live. If you would like to subscribe to OJJDP's NTTAC's TTA listserv, you can also text NTTAC to 22828. You can also find us on Facebook and like us on Facebook at OJJDP TTA. If you'd like to get in contact with the OJJDP Help Desk, you may do so at the information located on this slide. Do you have a training and technical assistance need? Well, if so, please submit a request via the OJJDP TTA platform. The link for that platform is located here on this slide. Also, as we mentioned before in the beginning, please note that this webinar is being recorded and will be available on our NTTAC YouTube channel. Please note that the YouTube channel link can be accessed there, but if you would like access to the transcript or the or any supporting materials, you may contact OJJDP@usdoj.gov. Please take a moment to review this slide, this disclaimer. And finally, just to let you all know about a couple of webinars that we have coming up, please join us for an upcoming event, including our APA webinar set for June 3rd. Please note that this webinar is indeed for only for prosecutors. And also our webinar with with the National Gang Center, not SHIFT, the Innocent Justice Foundation, that's incorrect. It's actually with the National Gang Center, Protecting Youth from Gangs on Social Media. That's coming up on June 30th. You can click on the Learn More button to learn more about each of those webinars. You can also select the Register Now to register for those webinars. And finally, our very last poll that we have for today. How do you plan to apply this information that you learned? As you see, there are many options that you can choose there, and you can also choose more than one option. If you could, please go and select the different options to where you indicate how you plan to apply the information for this webinar in your work. That being said, I'm going to go ahead and close us out and thank everyone again for joining us. I'll leave this poll up for folks to go ahead and complete if you would like, but please be sure to go in and check us out again, this recording on our YouTube page. If you have any questions or need any follow-up, please feel free to contact the OJJDP TTA Help Desk. Also note that there is a survey that will pop up at the very end of this presentation. The survey is currently being provided in the chat box. If you could, please take a moment to click that survey and provide our CFF colleagues with feedback for today's survey. But also note that the survey will come up at the very end of today's webinar as well. Again, thank you to our presenters, thank you to our moderator, Tessa, and thank you to our colleagues at CFF for another great and successful webinar. Everyone take care and have a wonderful afternoon. Goodbye. Thank you.